So at long last, we get a chance to talk about Citizens United, one of the most significant election law cases that the court has dealt with in recent years, or for that matter, in all the history of election law. What's covered in this lecture is the following. We're going to introduce the issues involved in regulation of corporations' campaign finance activity. Then we'll look at the pre-Citizens United history of the court's treatment of corporations, particularly in cases such as First National Bank of Boston versus Bellotti and Austin versus Michigan Chamber of Commerce. Third, we'll look at the BCRA ban on independent expenditures, which was just mentioned in a previous lecture. And this was a ban on independent expenditures from corporate and union treasury funds. And then finally, we'll analyze Citizens United and discuss its implications. So let's just start with general questions about corporations and campaign finance. The basic question is, should a standard that's different from the typical Buckley regime apply to corporations? So as you remember from the previous lectures, Buckley says that independent expenditures are regulations of independent expenditures are subject to strict scrutiny, and contribution restrictions are subject to Buckley scrutiny. They have to be closely drawn to prevent corruption or the appearance of corruption. Should that framework basically apply to corporate involvement in elections, or should it a new standard apply? And the basic story is that the court for many years had a different standard than Buckley that applied to corporate expenditures, and then in Citizens United, it has applied basically the same Buckley framework to corporate involvement in politics. Second, do corporations pose a unique threat of corruption? While it all might be of concern that an individual might give millions of dollars to a candidate or spend $1 million supporting that candidate, are there special concerns about corruption when a corporation or a union spends money or contributes money in political campaigns? Third, does a corporation's speech deserve less protection? And if so, why? Because in addition to the state interest in preventing corruption or the appearance of corruption and how that might be thought about in the campaign finance realm with respect to corporations, you might also ask the question whether corporations deserve the same level of speech protection as other kinds of entities. And fourth, when we talk about corporations, should we treat them all the same? How about media corporations? Do we need to distinguish between corporations when we think about their involvement in campaign activity? And then finally, I've been sort of going back and forth and talking about corporations versus corporations and unions. For purposes of campaign finance law, corporations and unions are basically treated the same. But you might ask the question, should they be? Should unions be subject to the same rules as corporations, or do they perform different types of functions? Is the nature of union campaign finance activity really the same as corporate campaign finance activity? So let's just start with a little background. So there is a long history in the United States of regulating corporate involvement in politics. If you read the full version of either Citizens United or in particular McConnell versus FEC, the court in McConnell goes through the long history of regulation of corporate involvement in politics, going back to the Tillman Act of 1907, which banned corporate contributions in connection with any federal election. That was followed 40 years later by the Hatch Act and Taft-Hartley Act, which basically applied the same kind of ban on union contributions and expenditures. Most of the attention in recent years before the BCRA, the Bipartisan Campaign Reform Act, focused on the FECA amendments, the Federal Election Campaign Amendments of 72 and 74, which ratified the ban on contribution expenditures from union and corporate treasury funds, but established a path for separate segregated funds. And so I want to just briefly explain what that means. We need to distinguish between treasury funds of corporations and unions on the one hand, and corporate and union PACs on the other. This may seem really complicated, but it's not. As a general rule, when we talk about treasury funds, we're talking about all of the money that these institutions have. So the profits that corporations garner from selling of widgets or their products, right, those go into the corporate treasuries. Similarly, the union contributions go into the union treasuries. Those are different than corporate or union-sponsored PACs, because corporate or union-sponsored PACs are institutions where the corporation or the union uses these treasury funds to pay for the overhead costs, like the office and the administrative staff. But any money that will be spent on politics has to come from actual people, meaning that members of the union would contribute in regulated amounts to the PAC, and then that money could be used on contributions or expenditures. Or employees or managers of the corporation or shareholders of the corporation can contribute money to the PAC, and then that would end up being spent on politics. But notice the difference here between treasury funds, which come from all kinds of sources like selling products, and PAC contributions, which come from actual people who are making contributions just like they would to candidates or other kinds of committees, but they would give it to the corporate or union PAC. So here are the key precedent pre-Citizens United dealing with corporate expenditures. Now, I don't want to just limit it to these particular cases. There are plenty of cases going back to the Tillman Act, which regulated corporate involvement in politics. But when we think about the precedent that was implicated by Citizens United, it's First National Bank of Boston versus Bellotti, which struck down a ban on corporate expenditures and initiative campaigns. It's Austin versus Michigan Chamber of Commerce in 1990, which upheld the ban on corporate expenditures on express advocacy in candidate campaigns. And then there's McConnell versus FEC, which originally upheld, almost in toto, the Bipartisan Campaign Reform Act, upheld both the soft money ban, which prevented corporations and unions from contributing money from their treasury funds to political parties, and then also the ban on independent expenditures for electioneering activities, which was then later overturned in Citizens United. So let's talk about First National Bank of Boston versus Bellotti. In that case, the court struck down a Massachusetts law that banned contributions or expenditures for the purpose of influencing or affecting the vote on any questions submitted to the voters. So notice that this is not a situation where there was a risk of quid pro quo with a candidate or an office holder. And so it really raises the issue as to whether and under what circumstances you might be able to ban corporate spending on issues. And the court here said, no, you cannot ban corporate spending on issues. And the reason is that it's not just about the corporation's right to speak. It's about the right of voters to hear what the corporation wants to say. And so as the court says in Bellotti, the inherent worth of the speech in terms of its capacity for informing the public doesn't depend upon the identity of its source, whether corporation, association, union, or individual. And so the court in Bellotti rejected the state's arguments about their special dangers that corporations posed to the initiative process, or reasons for lessened speech protection, like, as we'll talk about in a bit, protecting shareholders or otherwise being worried about how the corporations was using its treasury funds to manipulate an election. Here, because it's about issues, because it's about an initiative, the traditional corruption threat from Buckley, either quid pro quo or, as in Nixon, undue influence on an office holder's judgment, simply doesn't apply. Now, Austin versus Michigan Chamber of Commerce advances a distinctly different corruption interest. In that case, the court upheld the ban in Michigan on corporate contributions and spending in state elections. Now, you may wonder why, is the Michigan Chamber of Commerce actually a corporation? It acquired and received a lot of corporate money, and so therefore the ban on corporate spending in elections applied to them. But the court, as I said, identified a unique corruption threat from corporate involvement in elections, as well as a sort of diminished First Amendment right on the part of corporations to spend money on candidate advocacy. So to understand the history of corporations and campaign finance, you really have to understand this notion of what we call Austin-style corruption. And it comes from a specific sentence in that case, which designated a unique corruption interest as it relates to corporations. And that corruption interest was defined as the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. Now notice this is different from quid pro quo corruption in the Buckley sense, or even undue influence on an office holder's judgment. It's about the corrosive and distorting effects of the immense aggregations of wealth accumulated with the help of the corporate form. So this type of corruption is focused on the influence on elections, not necessarily on office holders. It's about corporate spending having an impact really on who wins and how corporate involvement in elections could corrode the democratic process, not necessarily about the influence that will have on the decision-making of office holders who win. And notice also how it tries to distinguish corporations as their money has little or no correlation to the public's support for the corporation's political ideas. Here, the court tries to highlight what are the differences between corporations and other kinds of associations of individuals. So as comes out of Austin and McConnell versus FEC and other cases dealing with corporations, the court highlights special legal advantages that corporations have, namely that they have limited liability, they have perpetual life, they don't die like ordinary individuals, and they get favorable legal treatment and especially tax treatment of their assets. And so what the court says is that these state-created advantages not only allow corporations to play a dominant role in the nation's economy, but also permit them to use resources amassed in the economic marketplace to obtain an unfair advantage in the political marketplace. And that's why the state can respond by trying to uniquely regulate corporate expenditures. And it's these kinds of special legal advantages that are said to distinguish corporations from other types of associations. Because corporate treasury money, really, the profits from selling widgets and other products, are different from individual wealth. Because as the court says, the resources in the treasury of a business corporation are not an indication of popular support for the corporation's political ideas. The availability of these resources may make a corporation a formidable political presence, even though the power of the corporation may be no reflection of the power of its ideas. That quote comes from a case called FEC versus Massachusetts Citizens for Life, but it's also cited in Austin versus Michigan Chamber of Commerce. And so the idea here is that when corporations spend money on politics, they're actually spending other people's money, namely the money that should otherwise be possessed by the shareholders. And so that when individuals spend their money on politics, you can sort of roughly correlate how much money they're spending based on their intensity of preference for that election and for the candidate. But when you're spending other people's money, when the corporation's managers are spending the money of the shareholders, it's not really connected to the support for the political ideas that the corporation is funding, because they're not really using their own individual money, they're using the money of the corporation and its profits. And that's why in many of these cases, you see a special state interest about protecting shareholders, so that when shareholders buy shares in a particular company, they're usually not buying it in order to spend money on candidate elections. The shareholders are buying shares in a corporation in order to try to, gain wealth over time so that the shares will increase in value. And so if you believe that corporate money is different and corporate associations are different, then you might, as the state, act on behalf of shareholders to restrict the ability of corporations to spend money on electioneering activity. Now, Justice Scalia has a kind of famous dissent in Austin versus Michigan Chamber of Commerce, which ends up winning the day in Citizens United, but it's worth reprinting here. And so here's how he starts the dissent. He says, "Attention all citizens, to assure the fairness of elections by preventing disproportionate expression of the views of any single powerful group, your government has decided that the following associations of persons shall be prohibited from speaking or writing in support of any candidate. In permitting Michigan to make private corporations the first object of this Orwellian pronouncement, the court today endorses the principle that too much speech is an evil that the Democratic majority can prescribe. I dissent because the principle is contrary to our case law and incompatible with the absolutely central truth of the First Amendment that government cannot be trusted to assure through censorship the fairness of political debate." And so that inclination, that view that you cannot regulate corporate spending because it's just like it has the same evils as other kinds of regulations of spending in the political sphere, in that it constitutes a kind of form of censorship, that view wins the day in Citizens United. And so between Austin and Citizens United is the enactment of the Bipartisan Campaign Reform Act, otherwise known as McCain-Feingold, which, as was discussed in previous lectures, was passed in order to deal with the problem of soft money, which was money from corporations and unions, as well as individuals beyond limits that were going into political parties because of different loopholes that had developed in the 1990s. And then the BCRA was also directly going after corporate or union-funded election advertisements that didn't use words of express advocacy. So as stated also in the previous lecture, here again is the definition of electioneering communications that was at issue in Citizens United. Dealt with any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office, is made within 60 days before a general or 30 days before a primary election, and is targeted to the relevant electorate. McConnell versus FEC upheld both the ban on soft money and the ban on electioneering expenditures from corporate and union treasury funds. Because McConnell versus FEC said Austin versus Michigan Chamber of Commerce settles the issue. We have long history of regulating corporate expenditures. There is a unique corruption interest here. And so therefore, it upheld the total ban on corporate treasury funds and union treasury funds from being used for electioneering expenditures. It laid the groundwork for the possibility that you could have a as-applied challenge to the Bipartisan Campaign Reform Act's electioneering provisions. Because as you can see from the words of the statute itself, that there may be situations in which a broadcast, cable, or satellite communication refers to a clearly identified candidate for public office, but it's not really about their election. So the court leaves open the possibility for an as-applied challenge, for example, if there was an ad that referred to candidates, but was not itself really about advocating for their election or defeat. And then that case, that type of example came up in 2007 in a case called Wisconsin Right to Life versus FEC. The court found an as-applied challenge, and it struck down the BCRA advertising provision as applied to a particular ad. In that case, the Wisconsin Right to Life received some corporate treasury money and wanted to run its radio ad within 60 days of the election. Because the ad references Wisconsin Senator Russ Feingold, who was on the ballot, then it gets captured by the definition of electoral communications in the Bipartisan Campaign Reform Act. The ad also referenced Senator Herb Kohl, who is not up for re-election, so it is kind of perfectly placed to try to challenge this issue advocacy, express advocacy distinction that the BCRA was trying to navigate. And so the question is this actually an electioneering communication, which might be governed by Austin and McConnell versus FEC, or is this an issue ad similar to what was protected in First National Bank of Boston versus Bellotti? So why don't you have a listen to this ad?
And who gives this woman to be married to this man?
Well, as father of the bride, I certainly could. But instead, I'd like to share a few tips on how to properly install drywall. Now, you put the drywall up.
Sometimes it's just not fair to delay an important decision. But you know, in Washington, it's happening. A group of senators is using the filibuster delay tactic to block federal judicial nominees from a simple yes or no vote, so qualified candidates don't get a chance to serve. Yes, it's politics at work, causing gridlock and backing up some of our courts to a state of emergency.
And then you get your joint compounding, your joint tape, and you put the tape up.
Contact Senators Feingold and Kohl and tell them to oppose the filibuster. Visit befair.org. That's befair.org.
Paid for by Wisconsin Right to Life, befair.org, which is responsible for the content of this advertising and not authorized by any candidate or candidates committee.
Notice that this ad does not expressly advocate for the election or defeat of Russ Feingold or Herb Kohl. It says contact Senators Feingold and Kohl to tell them to oppose the filibuster. And so, like the Bill Yellowtail ad that was described in the previous lecture, and many other ads that end with a kind of call to action of calling your representative, this was an attempt to try to avoid the magic words of express advocacy that were at issue in, say, Buckley versus Vallejo. And so here's how the court broke down. Chief Justice Roberts and Justice Alito, who were new to the court, found the law as unconstitutional as applied to this ad. And they said that after McConnell versus FEC, that for an ad to be regulable, it must be the functional equivalent of express advocacy, which means that it is only if the ad is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. That's what's meant by express advocacy. If you could interpret the ad as not being about an appeal to vote for or against a candidate, then it's constitutionally protected and you cannot ban the ad. Now, Justice Scalia, along with Justice Kennedy and Justice Thomas, would strike down the law in its face, which is what eventually happens in Citizens United. WRTL, Wisconsin Right to Life, is really a kind of way station between McConnell versus FEC and Citizens United. And then the more liberal members of the court, Justice Souter with Justices Stevens, Ginsburg, and Breyer, would not even allow for this as applied challenge. They would have found this to be captured by the express advocacy provision, which they believe to be constitutional for the same reasons that were explained in McConnell versus FEC. So what happened between McConnell versus FEC and Citizens United that led to this sea change in the jurisprudence on campaign finance? Well, after McConnell was handed down, Chief Justice Rehnquist died and Justice O'Connor left the court. And so they were replaced by Chief Justice Roberts and Justice Alito, who had very different views on campaign finance. Wisconsin Right to Life, as I said, followed a pattern that we saw in the Roberts Court in cases like Shelby County, where the court issues a more incremental decision that then lays the groundwork for a broad decision later on. This, by the way, in Wisconsin Right to Life itself, Justice Scalia in dissent called this faux judicial restraint. But ultimately in Citizens United, his opinion was vindicated. And so between WRTL and Citizens United, the court ended up hearing Citizens United actually twice. It was re-argued to consider the overruling of Austin and McConnell. We know from some journalistic accounts related to Citizens United that there was a lot of dissension on the court after the first oral argument in Citizens United, so much so that then the court said, all right, let's be clear that what our intentions are here, and we will ask the parties, the government and the plaintiffs here, to argue on whether Austin and McConnell should be overruled and whether corporations have a First Amendment right to engage in express advocacy. So let's start with the facts of Citizens United, because I think Citizens United is a frequently misunderstood case. So the facts in Citizens United are the following. A nonprofit ideological corporation called Citizens United, which got some of its funds from corporations, just as, say, Wisconsin Right to Life did, or just as the Michigan Chamber of Commerce did, that this ideological corporation produces a movie called Hillary the Movie. It pays to have that movie made available through video on-demand programming, as well as like mailing out DVDs to people. The Federal Election Commission prevents the move of the movie to on-demand programming because the video would be a broadcast communication referencing a candidate, Hillary Clinton, within 30 days of the 2008 Democratic presidential primary in certain states. And so it has all the classic features that would capture it under the express advocacy definition of the Bipartisan Campaign Reform Act. Broadcast communication, referencing a candidate within 30 days of the election, and it was targeted, it was available at least to people in the primary election states where Hillary Clinton was on the ballot. Now, how the court deals with this case is to overturn the relevant provisions of McConnell versus FEC and Austin versus Michigan Chamber of Commerce. And it holds that the BCRA's restrictions on corporate spending on express advocacy violate the First Amendment. That was a 5-4 decision because of now the switch of Justice O'Connor with Justice Alito. Notably, the court upholds a series of disclosure provisions that are also in the Bipartisan Campaign Reform Act that don't get a lot of attention. But I want to at least note that here, that it is actually an 8-1 decision with Justice Thomas dissenting, where the court upholds disclosure requirements, for example, who funded these particular ads, that those are seen as consistent with the First Amendment. So let's watch at least the trailer for Hillary the Movie so you can see what was actually at issue in the case.
The problem with nostalgia is what we tend to do is you only remember what you like. And you're right. And you forget the parts that you didn't like.
I can support the president. I can support an action against Saddam Hussein.
If I had been president,
In 2003, I never would have started this war.
Well, she's flipping, she's flopping. No, she's not flipping and flopping. She's lying.
My plan does not create a single new government department, agency, or bureaucracy.
That's what God put them on the earth to do, is make promises they can't keep.
I'm going to take $10 billion away from a lot of these industries.
Hillary is really the closest thing we have in America to a European socialist.
Oh, isn't that amazing? Oh, it's a woman. She can walk and talk.
She is steeped in controversy, steeped in sleaze.
Hillary Clinton, I know, is not equipped, not qualified to be our commander-in-chief.
The bigger this campaign is, the bigger the choice is, the more trouble she's in.
We must never underestimate this woman. We must never understate her chances of winning. And we must never forget the fundamental danger that this woman poses to every value that we hold dear. You see, I know her.
So let the conversation begin. I have a feeling it's going to be very interesting.
So after you watch even the trailer for the movie, you can see that this is pretty powerful anti-Hillary Clinton movie. The intent, at least with respect to taking her down, is pretty clear. But it's not express advocacy in the sense of, vote for or vote against. And part of the question is, should a movie receive the same treatment as, say, an advertisement that you would see on TV? Now, there are many different ways that the court could have avoided these big questions that were raised by McConnell and Austin. And Justice Stevens, in his dissent, takes the court to task for the fact that it reached out in order to overturn those classic precedent. The court could have said that ideological nonprofits like Citizens United are different than for-profit corporations, even though they might receive a little bit of corporate money. Second, they could have said that on-demand programming, like Hillary the movie, is different than broadcast TV. So you could say that it's not even within the corporate, the ban on corporate electioneering expenditures on broadcast communications in the traditional sense. You could have said that movies, as opposed to advertisements, right, raise different constitutional questions, and so you could have an as-applied challenge for movies, or you could interpret the statute as not applying to movies like this, as well as to commentary, which this clearly is, as opposed to advertising, which is sort of more sound bites that are advocating for the election or defeat of candidates. But the court instead goes all in and overrules Austin and McConnell. And for those who are confused by campaign finance law, it actually makes the law a lot clearer, because now corporations are treated just like other associations of individuals, in that their expenditures are subject to expenditure restrictions of corporations would be subject to strict scrutiny, and contributions would be subject to Buckley scrutiny. So let's just talk about Citizens United's treatment of precedent. The court describes Austin and McConnell as anomalies in the post-Buckley jurisprudence. It rejects any special corruption threat posed by corporate expenditures, kind of the corrosive and distorting effect of immense aggregations of wealth will master the corporate form, the notion of Austin-style corruption. That's completely rejected in Citizens United. It even suggests that these ads don't pose an undue influence on office holders' judgment. So it rejects the idea that expenditures could be reinterpreted in the kind of classic Buckley framework in the same way that contributions would. It also rejects the shareholder protection interest, in that shareholders are essentially on notice that their corporations might end up spending money on politics, and if they dislike that, well, then they can sell their shares in the corporation. Or they could act through the normal process of shareholder democracy of voting out the managers of the corporation. But the court in Citizens United views corporate speech as on a par with individual speech, which says political speech is indispensable to decision-making in a democracy, and this is no less true because the speech comes from a corporation rather than an individual. One of the most far-reaching aspects of Citizens United is the way it thinks about corruption, because this extends beyond the corporate campaign finance realm, potentially to all aspects of the Buckley regime. So the court really focuses on quid pro quo corruption, the idea of money going to a candidate in exchange for votes. That is now really the most of the corruption that's envisioned by the court's First Amendment jurisprudence post-Citizens United in the campaign finance realm is focused on quid pro quo corruption or something very similar to it. The court rejects Austin-style corruption, so that is off the table. It minimizes the notion of Nixon-style undue influence. The court says specifically that favoritism and influence are not avoidable in representative politics and susceptible of no limiting principle. So the question about how much of sort of Nixon-style corruption is still viable in campaign finance litigation is, I think, up for grabs. And then the whole sort of independent state notion of the appearance of corruption is also undermined in Citizens United, because the court says that the appearance of influence or access will not cause the electorate to lose faith in our democracy. By definition, an independent expenditure is political speech presented to the electorate that is not coordinated with a candidate. The fact that a corporation or any other speaker is willing to spend money to try to persuade voters presupposes that the people have the ultimate influence over elected officials. This is inconsistent with any suggestion that the electorate will refuse to take part in democratic governance because of additional political speech made by a corporation or any other speaker. And so while, as in previous lectures, I explained that the idea of the appearance of corruption interest was sometimes bolstered by the court because it was so difficult to prove actual corruption, Citizens United tells you that even this independent state interest, which is still out there as a viable kind of argument in litigation, but that the court is going to look much more narrowly at the idea of the appearance of corruption than it had, for example, in McConnell or in Nixon versus Shrink Missouri Government PAC or Austin. And if you thought that this was kind of dicta from Citizens United, a subsequent case called McCutcheon versus FEC reaffirms Citizens United's redefinition of corruption. And the case I talked about in the previous lecture, Speech Now versus FEC from the DC Circuit, which led to the rise of super PACs, also adopts the Citizens United view of corruption. Now, as we dive a little deeper into the arguments in Citizens United, there was a critical stage in the oral argument, the first oral argument in Citizens United, where Justice Alito brought up what I'll call the book banning hypothetical. He raised the question that if the FEC can prevent a corporation from broadcasting an on-demand movie, can it prevent such corporations from publishing books with the same content? So it's a little long, but listen to this section of the oral argument.
As applied to those advertisements, because those advertisements certainly would be susceptible of a reasonable construction.
Do you think the Constitution required Congress to draw the line where it did, limiting this to broadcast, cable, and so forth? What's your answer to Mr. Olson's point that there isn't any constitutional difference between the distribution of this movie on video demand and providing access on the internet, providing DVDs either through a commercial service or maybe in a public library, providing the same thing in a book? Would the Constitution permit the restriction of all of those as well?
I think the Constitution would have permitted Congress to apply the electioneering communication restrictions to the extent that they're otherwise constitutional under Wisconsin right to life. Those could have been applied to additional media as well. And it's worth remembering that the pre-existing Federal Election Campaign Act restrictions on corporate electioneering, which have been limited by this court's decisions to express advocacy.
That's pretty incredible. You think that if a book was published, a campaign biography that was the functional equivalent of express advocacy, that could be banned?
I'm not saying it could be banned. I'm saying that Congress could prohibit the use of corporate treasury funds and could require a corporation to publish it using its.
Well, most publishers are corporations. And a publisher that is a corporation could be prohibited from selling a book?
Well, of course, the statute contains its own media exemption for media.
But I'm not asking what the statute says. The government's position is that the First Amendment allows the banning of a book if it's published by a corporation.
Because the First Amendment refers both to freedom of speech and of the press, there would be a potential argument that media corporations, the institutional press, would have a greater First Amendment right. That question is obviously not presented here. The other two things.
Well, suppose it were an advocacy organization that had a book. Your position is that under the Constitution, the advertising for this book or the sale for the book itself could be prohibited within the 30-day period.
If the book contained the functional equivalent of express advocacy, that is, if it was subject to no reasonable interpretation.
And I suppose it could even, is it the Kindle where you can read a book? I take it that's from a satellite, so the existing statute would probably prohibit that under your view.
Well, the statute applies to cable, satellite, and broadcast communications. And the court in McConnell has addressed this question.
So just to make it clear, it's the government's position that under this statute, if this Kindle device where you can read a book, which is campaign advocacy, within the 30-day period, if it comes from a satellite, it can be prohibited under the Constitution and perhaps under this statute.
It can't be prohibited, but a corporation could be barred from using its general treasury funds to publish the book and could be required to raise funds to publish the book using its PAC.
If it has one name, one use of the candidate's name, it would be covered, correct?
That's correct.
If it's a 500-page book and at the end it says, and so vote for X, the government could ban that.
Well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provision.
No, I'm talking about under the Constitution, what we've been discussing, if it's a book.
If it's a book and it is produced, again, to leave to one side the question of
forget the
possible media exemption. If you had Citizens United or General Motors using general treasury funds to publish a book that said at the outset, for instance, Hillary Clinton's election would be a disaster for
this. Take my hypothetical. It doesn't say at the outset. It runs, here is whatever it is. This is a discussion of the American political system. And at the end it says vote for X.
Yes, our position would be that the corporation could be required to use PAC funds rather than general treasury
funds. And if they didn't, you could ban it.
If they didn't, we could prohibit the publication of the book using the corporate treasury fund.
So you can see that Deputy Solicitor General Malcolm Stewart had a real hard time trying to distinguish between corporate expenditures on, say, television ads or movies and corporate expenditures on books. I'm told that when he conceded that the FEC could ban a book if it was produced through corporate expenditures, that when he made that concession, that there was an audible intake of air in the Supreme Court courtroom. The idea that the federal government just conceded the possibility that it could ban books consistent with the First Amendment. So if you learn nothing else in all of these lectures and you're arguing before the Supreme Court, try not to be on the side of book banning. So that interchange led to a re-argument in the case that was ordered by the court the following fall on September 9th, 2009, when then Solicitor General Elena Kagan had her chance to try to distinguish between, say, corporate expenditures on on-demand movies from corporate expenditures on books. So let's take a listen to how she tried to deal with that issue.
I see my time is up.
May I ask you just one question that was highlighted in the prior argument, and that was, if Congress could say no TV and radio ads, could it also say no newspaper ads, no campaign biographies? Last time the answer was yes, Congress could, but it didn't. Is that still the government's answer?
The government's answer has changed, Justice Ginsburg. It is still true that BCRA 203, which is the only statute involved in this case, does not apply to books or anything other than broadcast. 441B does, on its face, apply to other media. And we took the court's own reaction to some of those hypotheticals very seriously. We went back, we considered the matter carefully, and the government's view is that although 441B does cover full-length books, that there would be a quite good as-applied challenge to any attempt to apply 441B in that context. And I should say that the FEC has never applied 441B in that context. So for 60 years, a book has never been at issue.
What happened to the overbreadth doctrine? I mean, I thought our doctrine in the First Amendment is if you write it too broadly, we're not going to pare it back to the point where it's constitutional. If it's overbroad, it's invalid. What happened to that?
I don't think that it would be substantially overbroad, Justice Scalia, if I tell you that the FEC has never applied this statute to a book. To say that it doesn't apply to books is to take off, essentially nothing from the historic.
We don't put our First Amendment rights in the hands of FEC bureaucrats. And if you say you're not going to apply it to a book, what about a pamphlet?
I think a pamphlet would be different. A pamphlet is pretty classic electioneering. So this is no attempt to say that 441B only applies to video and not to print.
Well, what if the particular movie involved here had not been distributed by video on demand? Suppose that people could view it for free on Netflix over the internet. Suppose that free DVDs were passed out. Suppose people could attend the movie for free in a movie theater. Suppose the exact text of this was distributed in a printed form. Now, in light of your retraction, I have no idea where the government would draw the line with respect to the medium that could be prohibited.
Yes, well, none of those things, again, are covered.
No, but could they? Which of them could and which could not? I understand you to say books could not.
Yes, I think what we're saying is that there has never been an enforcement action for books. Nobody has ever suggested, nobody in Congress, nobody in the administrative apparatus has ever suggested that books pose any kind of corruption problem. So I think that there would be a good as-applied challenge with respect to that.
So you're a lawyer advising somebody who's about to come up with a book, and you say, don't worry. The FEC has never tried to send somebody to prison for this. The statute covers it, but don't worry. The FEC has never done it. That going to comfort your client? I don't think so.
But this statute doesn't cover books.
No, that's exactly right. The only statute that's involved in this case does not cover books. So 441B, which
does cover books,
which does cover books, except that I've just said that there would be a good as-applied challenge, and that there has been no administrative practice of ever applying it to books, and also only applies to express advocacy. Right? 203 has a broader category of the functional equivalent of express advocacy, but 441B is only express advocacy, which part of the reason why it's never applied to a book is one cannot imagine very many books that would meet the definition of express advocacy as this court has understood that.
I'm sorry, that we suggested some in the last argument. You have a history of union organizing and union involvement in politics, and the last sentence says, in light of all this, vote for Jones.
I think that wouldn't be covered, Mr. Chief Justice. The FEC is very careful and says this in all its regulations to view matters as a whole. And as a whole, that book would not count as express advocacy.
Thank you, General.
So as you can see, she didn't have much more luck than Malcolm Stewart did in her argument. But it does raise the question, and ask yourself this question: is the problem with corporate expenditures that they are expenditures from corporations, or is it that we have a problem with the way corporations might spend money on, say, television and radio broadcast ads? And so this interchange really does raise the issue as to whether the discomfort that legislators or many of us feel with corporate expenditures on politics really is focused on the unique nature of television and broadcast advertisements, or is it about the corporate character of the expenditure? So you can think about in Citizens United as having an issue with the medium and the media. If corporations don't have First Amendment rights, then Congress might be able to prevent corporations publish publications of books or websites if they contain references to candidates. Similarly, how should the court or Congress deal with media corporations? Because if you're someone who believes that corporations have no First Amendment rights, well, then what about the New York Times Corporation or News Corp or NBC, Comcast? These are all news corporations, that if they were prevented from referring to clearly identified candidates for public office within 60 days of an election, would completely obliterate news coverage. So it can't be that the First Amendment allows for regulation of media companies that want to spend their treasury funds on references to candidates in the run-up to an election. So how do we distinguish constitutionally between media corporations on the one hand and other kinds of corporations engaging in express advocacy? In the Bipartisan Campaign Reform Act and its predecessor, the Federal Election Campaign Act, there was a media exception. So they made clear that electioneering communications don't include a communication appearing in a news story, commentary, or editorial distributed through the facilities of any broadcasting station, unless such facilities are owned or controlled by a political party, political committee, or candidate. Elsewhere, it talks about any news story, commentary, or editorial distributed through the facilities of any newspaper, magazine, or other periodical publication. So in the statutes, we have had these exceptions for the media. But are those constitutionally required? Because if the general rule is that corporations can have a corrosive and distorting effect on the political process, could the same be said for media corporations? The media exception to campaign finance law poses several kind of conceptual challenges. First, the general one, which is why should media corporations enjoy First Amendment rights that other corporations don't? But then second, especially in this day and age, where anybody can essentially become the media by tweeting or putting up a YouTube video or a website, who should be counted as the media in the internet age? And should we feel differently about television in particular than other kinds of media? Is that warranted? Justice Stevens in Randall versus Sorrell, in his separate opinion, said, just as a driver need not use a Hummer to reach her destination, so a candidate need not flood the airwaves with ceaseless sound bites of trivial information in order to provide voters with reasons to support her. So in a series of opinions, Justice Stevens is particularly concerned about manipulation of the broadcast media by corporations through their television ads and sound bites. But that's true. He feels that way about political commercials generally, as you could see from that quote from Randall versus Sorrell. Now, there is an argument that is sort of lurking in some of these dissents that we could carve out an exception for the institutional media because the freedom of speech in the First Amendment is also supplemented by freedom of the press. And so you could say that when it comes to the press, that they get a special exception and special treatment from First Amendment law. Now, that's not the way the Supreme Court has interpreted the First Amendment. When the court has interpreted the press clause, it's about just the act of publishing something through the press. It's not about a particular group of people who we call the press. And that's why journalists don't have any specific protection under the First Amendment that you and I don't have. That basically the First Amendment, whether it's the press clause or the speech clause, applies to everyone equally. So let's talk a little bit about the dissent in Citizens United. Justice Stevens' dissent, first of all, goes through the narrower grounds that the court could have used in order to adjudicate this case, which I referenced earlier. Second, he excoriates the majority for its disrespect of precedent and the long history of regulation of corporate campaign finance activity. He emphasizes that corporations and unions are still able to spend on express advocacy. They just needed to do so through their PACs. Remember that these special segregated fund PACs of corporations, this is where money from the shareholders, money from the managers, money from actual people as opposed to from the sale of widgets, that money would go into a political action committee and it could be spent on express advocacy. And so he thinks that a lot of this colloquy between the solicitors general and the court misunderstands that actually that corporations are able to spend for express advocacy out of their political action committees. One thing that Justice Stevens identifies in the majority's opinion, and for that matter, in just the idea of striking down bans on corporate electioneering activity, is how do you deal with the problem of multinational corporations and foreign nationals? Because unlike an individual who you can point to, where you know whether they're a U.S. citizen or where they reside, when it comes to corporations, they could have owners all around the world. Justice Stevens also raises a unique concern with respect to corporations, and that has to do with how we should deal with multinational corporations. or corporations that just have a significant share of their ownership not in the United States. With individuals and their campaign finance activity, you can know whether they are actual citizens and whether they reside in the United States. But corporations are free-floating entities where their ownership could be anywhere around the world. And so if the First Amendment and if campaign finance law is to treat out-of-country citizens, foreign nationals, differently than American citizens, well, then allowing for unlimited spending by corporations potentially blasts a large loophole in the campaign finance laws by allowing entities outside the United States to have significant influence on American politics. And then finally, Justice Stevens echoes one thing he said in McConnell versus FEC, which is that Congress really deserves deference, that the court shouldn't be micromanaging campaign finance. The response from the majority in many cases is that no, this is not an area where Congress deserves deference, that actually there's a real risk of incumbent protection here, and that those who are crafting the campaign finance laws are essentially designing the laws in a way that would hurt competitors. But as the court held in McConnell, and as Justice Stevens' dissent in Citizens United emphasizes, that this is an area where Congress also has expertise because they certainly know the campaign laws better than anyone. So here are the questions that are remaining after Citizens United. As you know, Citizens United was limited to the electioneering provisions of the Bipartisan Campaign Reform Act, not the soft money ban, which was upheld in McConnell versus FEC, and to this day is still on the books. And so part of the question is, if corporations are going to be treated just like other associations of individuals, which is what Citizens United does, can you still justify the ban on corporate and union treasury money being used in contributions? Because the soft money ban is an actual ban. It's not a limit on corporate and union contributions to political parties. So can you justify that wholesale ban? Second, as Justice Stevens raised in his dissent, how does the Citizens United opinion affect the restrictions on foreign nationals participating in U.S. campaigns, either through corporations or just on their own? Could we see a decision later on about their First Amendment rights? And how foreign does a corporation need to be before it can be banned from spending money in connection with elections? Because the ban on foreign nationals spending on express advocacy in American elections is still on the books. And so the question is to what extent does Citizens United cast doubt on that provision? And given all of these concerns in Citizens United that were expressed about, say, the medium of political communication, remember even Justice Kennedy talking about, what about that Kindle thing? How should we think about books that are available on a Kindle? Because isn't that essentially a broadcast communication? Well, that colloquy and the decision itself raises the question about how we should think about online paid communication with respect to the federal campaign finance laws. Because although there are restrictions on how, say, undisclosed expenditures online and campaign expenditures online, the internet still remains pretty much a Wild West when it comes to federal campaign regulations. And so we see that the platforms, places like Facebook and YouTube, are now in the position of trying to sort of fill the gaps that are in the law, so that they've developed rules on transparency and sometimes bans on certain types of express advocacy related to election. So I want to emphasize, as I did in the discussion of Citizens United, that disclosure is still a constitutionally safe option for legislatures that are looking to regulate campaign finance activity. So long as the disclosure is not too burdensome and doesn't target particular groups or lead to harassment, as a general rule, the 8-1 decision on disclosure from Citizens United still stands, as well as narrowly tailored contribution restrictions that pass Buckley scrutiny. That is what Randall versus Sorrell and McConnell versus FEC make clear. Beyond disclosure and contribution restrictions, states and localities can still design well-funded public funding systems. Programs that provide public funds to individual candidates or to political parties are constitutionally safe so long as they're not unduly coercive. And then finally, this ban on foreign nationals participating in electioneering does seem safe for now, but the question is whether the logic of Citizens United could eventually be extended to them.